Hello students, I am Ramakrishna Das, Faculty of Law from National Law University, Odisha. Today I like to discuss about the concept of private defense. In this module, we will include what is meant by private defense, when this defense is available, on what circumstances this defense will not be available, if suppose what is the punishment which is prescribed under law, what is the criminal liability under this concept private defense. So, let us start with the basic aspects of criminal law. As we know, the crime is based on two principles, that is actus reus and mens rea, that we all know all these two concepts. The entire penal code, Indian penal code, is based on these two concepts, that is actus reus and mens rea. That means the every act which is described under the Indian penal code, it directly or indirectly involves the actus reus and mens rea element. But at the same time, if you are discussing about the entire act which is described under the Indian penal code, chapter 4 of the IPC clearly explains some kinds of acts. Section 76 to 106 of IPC explains certain acts which lacks mens rea. Since there is no mens rea, all the acts which is done under section 76 to 106 will not be considered as a crime. So, the acts which is done under section 76 to 106 will be exempted from criminal liability. See, under the general exceptions, as I said, the entire general exceptions springs on the principle that there is no mens rea. Under these general exceptions, we can classify it into excusable and justifiable offences. The first category is where the law excuses certain class of persons even though their acts constitute an offence. For example, act of an insane, infants or intoxicated acts under mistake of fact or by accident. The second category, that is justifiable offence. The second category is where the acts committed though are offences and held to be justifiable under certain circumstances and hence exempted from the provisions of IPC. For example, judicial acts, acts done out of necessity, under duress, with consent, trivial incidents and acts done in private defense. When an individual citizen or his property is faced with a danger and immediate aid from the state machinery which is not readily available, the individual citizen is entitled to protect himself and his property. It also recognizes that the violence which the citizen is defending himself or for his property is entitled to use must not be unduly disproportionate to the injury which is to be averted or which is reasonably apprehended and should not exceed its limits. That is very important. The exercise of right to private defense must never be vindictive or malicious. The right to private defense is based on the cardinal principle that the primary duty of a man is to help himself. Let us discuss about the rationale of the concept of private defense. See, as we know, as per our constitutional provisions, a state is under an obligation to protect life, limb and property of its subjects. However, it is not possible for the state to extend its help to all individuals all the times and in all the cases. In such a situation, individual in pursuit of his basic instinct of self-preservation will be forced to resort to all the possible means at his command to protect himself and his property. The right to private defense originates from the idea that a person has an inherent right to protect himself by effective self-resistance against a lawful aggressor, or no individual expected to run away but to retaliate when his life, limb or property is in jeopardy. It rests upon the general principle that where a crime is endeavoured to be committed by force, it is lawful to repeal that force in self-defense. Section, as I said, section 96 to 106 of chapter 4 deals with the private defense. And section 96 to 106 deals a comprehensive legislative framework of right of private defense. All the provisions have to read together to have proper grasp of the scope and limitations of the right of private defense. The entire scheme of private defense, it is based on these four principles. First one is, every person is entitled to protect himself and others against unlawful attack upon their person and property. When its aid can be obtained, it must be resorted to. When its aid cannot be obtained, the individual may do everything that is necessary to protect himself. But the violence used must be in proportion to the injury to be averted and must not be employed for the gratification of vindictive or malicious feelings. These four essentials are very, very important in order to consider whether a particular act is a self-defense or not. Indian law on the subject of private defense is much wider in scope than the Anglo-American legal system. In India, the right of private defense is available not only for the protection of life of the property of a person himself, but also the person and the property of others. But in English law, the main difference between Indian law and English law is one can exercise the right of private defense only in defense of himself and his immediate kindred. Section 96 gives a statutory recognition to the right of private defense. It reads as, nothing is an offence which is done in exercise of right of private defense. But this right is not an absolute right. This right is limited, it is subject to the limitations contained in section 99 to 106. The right under section 96 is basically preventive in nature and not punitive. It is exercised only to repel unlawful aggression and not to punish the aggressor for the offence committed by him. With regard to the right to defense against the property of his own or another person is available only when there is theft, robbery, mischief or criminal trespass or attempt to commit any of the offence. There is one case in Hukum Singh versus State of UP. It was held that the owner of the land has right to use necessary force if the trespassers fails to remove the trespass. And again another question was whether in the case of free fight, whether private defense can be exercised or not. In a case of free fight, both the parties are aggressors and none of them is entitled to claim right of private defense. An appropriate test for determining as to whether a fight is a free fight or not is to see whether the parties voluntarily entered into fight with mutual interest to harm each other. The question who attacked first is it is immaterial, it is not a question at all. In Vishav versus State of Maharashtra, the court held that in a free fight there is no right of private defense to either party and each one is responsible for his own acts. Now, the right of private defense is not available against lawful acts. In Conver Singh versus Delhi administration, it was held that when a party is exercising a lawful act under law or any other authority, the accused has no right to private defense. Further, the aggressor has no right to private defense, held in Chako versus State of Kerala also. So, in these two cases, it was held that if a person is doing a lawful act in a lawful manner, then there is no question of private defense. This would be so even if the person exercising the right of private defense has the better of the aggressor, provided he does not exceed the right, because the moment he exceeds it, he commits an offence. Next is unlawful assembly and private defense. When 5 or more persons come together to form an assembly in order to assert their private defense either in respect of their person, body or property, such an assembly cannot be termed as unlawful assembly. The moment when they use unlawful force, they constitute unlawful assembly. In State of Bihar versus Nathu Pandey, the Supreme Court held that the assembly cannot be designated as an unlawful assembly if its object is to defend property by the use of force within the limits prescribed by law. Section 98 says, right of private defense is also available against an offence committed by a person who might not be criminally liable for his act on account of four elements. One is reason of youth, want of maturity of understanding, unsoundness of mind or intoxicating, or misconception on the part of the doer. This section ensures that a person does not lose his right of private defense merely because the opposite party is legally incompetent to commit the offence and is protected because of legal abnormality. The right of private defense is available only against the commission of offences. If the acts of the lunatic or the intoxicated persons or acts done under mistakes are not offences. The under section 98, which categorically stated that who is committing the crime, that is irrelevant. The only essential ingredient under section 98 or under the concept of private defense, that is the person who is committing offence against a person, and such act must be an unlawful act. Section 98 is based on the fact that right of private defense arises from human instinct of self-preservation and not from any supposed criminality of the person who possesses danger to body and property. In Munshiram versus Delhi administration, the court observed that even if an accused does not plead self-defense, it is open to the court to consider such a plea if the same arises from material on record. Next is with relating to the burden of proof. Section 105 of the Indian Evidence Act says, if the accused person claims the protection of right of private defense or under any of the defense under a general exception, the burden is upon the accused person. This is an irrebuttable presumption. This burden will be discharged by showing preponderance of probability in favor of the plea on the basis of material on record. Section 99 states the circumstances in which there is no right of private defense. There is no right of private defense. The first one is there is no right of private defense against an act done or attempted to be done or by the direction of a public servant. The public servant must have done the act in good faith and under color of his office, even though the act may not be justified by law. The second condition is there is no right of private defense in a case where there is time to recourse the public authorities. The mere fact that the police station is very far from the place of incidents cannot deprive a person of his right of private defense. The third one is there is no right of private defense, or in no case private defense shall extend to infliction of more harm than is necessary for the purpose of defense. If the public servant acted bona fidely under authority, but going beyond his authority, the accused has a right to exercise private defense on the ground of exceeding his authority. With respect to the second limitation, a person is not entitled to claim right of private defense merely on the ground that he is acting under the directions of public authority, but this information shall be communicated to the accused or the person concerned. The section ensures that the right of private defense can be exercised till he comes to the knowledge that the person is acting under the directions of the public authority. So, it is essential that the fact shall be communicated to the person concerned. If the person, if suppose for example, if a police officer who is acting under the authority or under the order of the court and the same information is not communicated to the other person, to the accused person has the right to exercise private defense. But the section categorically says that this order, under what authority he is acting, this order or this information shall be communicated to the other party, after that he can act upon. With respect to third limitation, when the accused continued to assault the deceased after he had fallen down and rendered harmless, it was held that there was no right of private defense. Section 100 provides the right of private defense of body extend to the causing of death to the assailant. If the offencer is an assault of any one of the following description, first one, an an assault resulting in the apprehension of causing death. The second one is an assault resulting in the apprehension of causing grievous hurt. The third one is an assault with the intention of committing rape. The fourth one is an assault with the intention of gratifying unnatural lust. Fifth one, an assault with the intention of kidnapping or abduction, and the last one is an assault with the intention of wrongfully confining a person, which may reasonably cause the apprehension that the man may not be able to contact public authorities for help. See, this section 100 is based on 4 principles. First one is the accused must be free from fault in bringing about the encounters. The second one is there must be present an impending peril to life or the great bodily harm. The third one is there must be no safe or reasonable mode of escape by retreat. And the last one is there must have been a necessity for taking life. These are the 4 essential ingredients or essential principles which is underlined in section 100. The right of private defense cannot be based on surmises and speculations. The accused must be under a bona fide fear that the death or grievous hurt would otherwise be the consequence of the assault if he does not defend. Killing in the exercise of right of private defense would be justified only if there was an honest and well-founded belief in the imminence of danger. It is not necessary that actual injury should be caused by the aggressor or the victim before the right of self-defense can be availed of. Person apprehending danger is not required to wait for sustaining injury. Mere reasonable apprehension is sufficient for exercising the right of private defense. So, that is very important. In order to exercise right of private defense, it is not necessary that the victim should suffered any injury, or mere apprehension of injury is enough to exercise right of private defense. Further, section 106 says the right of private defense also extend to the taking of risk to life of innocent persons under the following circumstances. First one is there is a reasonable apprehension of death. The second one is the person is so situated that he cannot effectively exercise the right of private defense without doing harm to innocent persons. So, that is very important. Under section 106, in order to exercise the right of private defense, it may cause injury to an innocent person, that is immaterial. The first law which under the first principle which is included under section 96 to 106 is self preservation. In order to protect himself, a person can cause harm to an innocent person. Under section 103, the right of private defense also extends to voluntary causing of death to the assailant in the case of danger to property resulting from any one of the following offences. First one is robbery. Second one is housebreaking by night. Third one is mischief by fire to any building, vessel used for dwelling purposes or custody of property. The fourth one is theft, mischief or house trespass under such circumstances as may reasonably cause the apprehension that death or grievous hurt may be caused. Right to private defense of trespasser. The Supreme Court in Puran Singh vs. State of Punjab laid down 4 criteria which the trespasser may entitle to exercise right of private defense of property and person. First one is the trespasser must be in actual possession of property over a sufficient long period. The second one is the possession must be in the knowledge, either express or implied, of the owner or without any concealment, and which contains an element of animus possidendi. The third one is the process of disposition of the true owner by the trespasser must be complete and final. And the last point is one of the usual rest to determine settle possession of the true owner by the trespasser in the case of cultivable land would be whether any crop has been grown on the land. If the crop has been grown, even the true owner has no right to destroy the crop grown by the trespasser. As per the provisions of section 101 and 104, the right of private defence of body and of the property extends to the voluntary causing of any harm short of death to the assailant. This is applicable in respect of cases other than those mentioned in section 100, 103 and 106. The next is when the private defences commences and when this private defence what ends. This is a very important question, because since when a case came before a court of law, the first question is when the private defence of a person commences and when it what ends. If a person what committed an offence, suppose the victim committed or accused person committed an offence in the name of private defence, after the completion or after the end of exercising private defence, then it will not be counted as a private defence. So, that is very important to determine when the right of private defence begins and when it ends. It is specifically mentioned in section 102 and 105 of the Act, which says that the right commences as soon as reasonable apprehension of danger to human body or to the property arises from an attempt or threat to commit the offence, though the offence may not have been committed. The right comes to an end as soon as the threat of assault has ceased and the apprehension of danger has been removed. So, that is very important. So, the section very categorically says when a danger to a body or property commences, then the right to private defence starts. When the danger to the body and the property ends, when the right to private defence comes to an end. In the case of theft, the right of private defence continues till the offender has effected his retreat. In the case of housebreaking by night, the right of private defence commences so long as housebreaking continues. Let us discuss some case laws. In Gurdatta Mall versus State of UP, in this case, the accused and the deceased consisted of a huge number of members. An accused consisted of a group killed some of the members of the deceased party. The accused pleaded the defence of right of private defence. The question was whether can we invoke the concept of private defence in this particular case. In order to adjudicate this particular case, we have to again rely on whether the fight between these two groups are a free fight or not. In the case of, as I discussed earlier, in the case of free fight, the doctrine of private defence will not be applicable. And here the trial court acquitted all the accused person under the benefit of doubt. While the matter came before the court of law, before the appellate Supreme Court, the first matter was whether this matter is a fit to invoke private defence. The second one was if it is a free fight, then this matter will not be, the accused are not entitled to get the benefits of private defence. So, here the court come to a conclusion that the basic principle of private defence, when a person can invoke the private defence, as we discussed earlier, the private defence can be invoked when there is an imminent danger and there is a reasonable apprehension of danger to the body or to the life or limb. In such a cases, a person can very well exercise the right of private defence. So, here in this case the court come to a conclusion this is not a fit case to exercise the right of private defence, since there is no threat to body, life or limb, because it is a free fight between two groups. So, here when the matter came before the Supreme Court held that this is not a fit case to invoke private defence. So, the court held that all the accused persons are guilty for committing murder of the other persons. In another case, R versus Rose, is a very famous English case. The accused shot and killed his father, whom he believed to be cutting the throat of his mother. The accused was allowed the right of private defense to protect his mother against his father's act. When the matter came before the court, it is allowed. But the question is, here the accused is really under the impression that his father is about to kill his mother. The question is whether in this particular circumstances he didn't cause any injury to his mother. The the accused is under the impression that he is about to kill his mother. The question is, in such cases, whether private defense can be invoked or not. As I discussed, in order to invoke or in order to exercise the right of private defense, an injury, it is not necessary that injury must be caused to the other party. What is necessary is even a reasonable apprehension which is likely to cause harm to the body or to the property, body of himself or body of another person, or the property of himself or the property of other person, that reasonable apprehension is sufficient to exercise the right of private defense. So that is why in this particular case the court invoked the doctrine of private defense. In another case, Gobi versus King. In this case, a sub-inspector proposed a search contrary to law. While doing his job, the accused person pushed him to prevent the search. The question is whether, and the matter came before the court of law because a person, ordinary person, he is obstructing a public servant from discharging his official duty. So he is prosecuted under law. The question is whether can he claim the benefit of private defense. As we know, what are the proceedings which a person has to be followed at the time of search? First thing is he has to get an order from the court of law. There must be a search warrant, and at the time of search he must produce the search warrant to the occupant of the builder or the owner of the house. And after that, the law says if he is convinced the order is issued by a competent court of law, then the owner shall liberate himself to conduct a search in his house. This is what the law says. When a person who is coming to your house at midnight without any proper record and he is asking to conduct a search in your house, the first question is whether the search is lawful or not. So here from the facts it is clear that the search which the police officer proposed to conduct is not as per the law. The question is, if it is not as per the law, whether the other party have any right to exercise private defense. So here the law is very clear. The section from 96 to 106 very clearly categorically says that if an officer who is under lawful authority, then there is no question of private defense. If a person, even though he is a police officer or some other instruments of states, the question is whether he is exercising his lawful authority in a lawful manner by lawful means. That is very important. So here in this case, the police officer came for search without any which is contrary to the law. In such cases, the law allows the other party, the owner of the house, to exercise a right of private defense. In such a case, even though he is in a uniform or not, the accused person has the right to exercise the right of private defense. And the court held not guilty of any offence since the sub-inspector did not act in good faith. Because there, and one more point is, in order to conduct a search, or in order to conduct, if suppose a person is acting under authority of law, he must show what is his authority to the other party. If he fails to do so, definitely the other person has the right to exercise right to private defense. In Dara Singh versus Emperor, police entered the accused house in the night to arrest him. The accused did not recognize or identify them as police and he fired at them. The question was whether the accused has any right to private defense at this point of time. See, first question is, the police entered the accused house at night. The object of the trespass was to arrest the accused persons. See here, under the law, which clearly under the chapter from section 96 to 106, it is clearly mentioned that every person has a right to private defense against every person, including trespassers. If a person who is come with a proper order or which is not contrary to the law or as per the provisions of law, it doesn't mean that the other person doesn't have any right to private defense. What the law says is, if a person is entering into other person's property, others property, then he must show on what grounds he enters into the property and what is your authority to enters into your property. If you are a public servant, then you have to communicate to the other party that I am a public servant and my purpose of visit or my purpose of trespass is such and such. If he is communicated to the other party in the same way, then the other party doesn't have any right to exercise right of private defense, that we already discussed. In this case also, the court took the same ratio and held that the accused person has a right to private defense since the other police officers doesn't communicate it in the proper way. And again, if the public servant who was in different uniform and his position would be known to the others, and in such circumstances the question is whether they have any right to private defense or not. See here, the law said, in this case the court said, even though if the police officers are not in uniform and the other party knows that the person who entered into his property, they are the police officers, then that is immaterial whether they are in uniform or not. The only question is, the other party must be aware about the assailant, whether they are a public servant or not. In another case, Krishna versus State of Madras, the accused, a trader, abducted and assaulted the sales tax officer who inspected the shop and attempted to seize the accounts. The accused pleaded the right of private defense. The question was whether he can be prosecuted, whether he can be held guilty or not. See, the question was, here in this particular case, he abducted the sales tax officer, and the question is whether what is the intention. So here it is clear from the very facts itself, it is clear he abducted with an intention to assault the sales tax officer who attempt to seize the accounts of the accused persons. So there we cannot say that we cannot invoke the right of private defense, because it is a voluntary act. The act is, and there is no threat to the life of the accused person. As I said, the right to private defense can be exercised only when there is a threat to the life or to the property. In such circumstances only right to private defense can be invoked. In no other circumstances right to private defense cannot be invoked. In another case, Karmanath Hussain versus Emperor, the accused, in order to save or protect his sister from the merciless beating by her husband, intervened and killed him. So the question is again, in such cases whether private defense can be exercised. Yes, of course. In this case also private defense can be exercised, because the law clearly, section 97 clearly says that private defense is available against his own body and the body of another persons. Plus there is a reasonable apprehension to the body or to the property. So in this case the ingredients are satisfied, so the person can very well claim the benefit of private defense. So these are some of the case laws which is relating to the private defense. So let us conclude. What is the real outcome of this lecture? See, the entire lecture says that the cardinal principle of private defense is self-protection or self-defense. When a person has no alternative, no time to recourse the public, or no other way to escape from the danger, in such cases, or there is a threat to the life, in such cases law assumes that every person has a right to protect himself, and the concept of private defense has been evolved from this principle, and it is attached. And one more thing, the doctrine of private defense is applicable only when the state fails to give protection to its subjects. The moment when the state fails to give protection to its subjects, the individual is at liberty to exercise or to is an obligation to protect himself. So that is what the inner meaning of the concept of private defense. And one more point is, whenever, if suppose a lawyer is using private defense as a defense, then as we know, the initial burden is always upon the accused persons or the defense counsel. That if the defense counsel failed to prove his case, then there is only one conclusion, that is conviction. So the person who is claiming or taking the defense, private defense, then he must prove his case. Otherwise, then the presumption is the conviction is 100% sure. Then there is no question of shifting of burden from the accused person to the prosecution. From the very beginning itself, if the defense counsel fails, then the case there is no question of case, then the defense will not stand. That means, so whenever the lawyer takes such a defenses, we should be very careful. Thank you.